Good morning. My name is Robert Meising. I'm chair of the International Department of Reinhart, Berner Van Duren. Reinhart, Berner Van Duren is a business firm oriented towards business clients. We're a 220-person firm, attorney firm, with attorneys located in Milwaukee, Rockford, Chicago, Madison, Denver, and Phoenix, and Waukesha. We like to believe that we serve the business client. This is our fifth and final webinar in a series to show foreign clients and attorneys about relevant legal issues that they may encounter in the United States. Previously this spring, we talked about U.S. corporate issues. Then we talked about U.S. immigration issues and U.S. tax issues. Several weeks ago, we spoke about dispute resolution and litigation in the United States. Today, we're going to talk about U.S. intellectual property issues, and it's my pleasure to introduce my partner, Jeremy Bridge. Jeremy is a shareholder and registered patent attorney in our firm's intellectual property practice, and he's based in Rockford, Illinois. Jeremy serves a wide range of business clients. His background in mechanical engineering allows him to understand the special intellectual needs and challenges of clients. He drafts and prosecutes patent applications and provides validity and infringement opinions on a wide range of cutting-edge technologies. Jeremy?
Thanks, Rob, for that great introduction. As Rob mentioned, I will be talking about U.S. intellectual property issues today. I will generally discuss the areas of intellectual property that are recognized in the United States, and then I will dive a little deeper into my specialty, which relates to patents, and more on the side of patent acquisition, but the discussion relating to patents will be on a higher level geared towards business attorneys so that they have some understanding as to how patents relate in the U.S. and what they can do if they have high-level questions from their clients on patents in the United States. There are four principal types of intellectual property in the United States. There are patents, there are copyrights, there's trademarks or trade dress, and trade secrets. Within patents, there are three different types of patents that are generally recognized in the United States. There are utility patents, and utility patents are those that cover products or processes. Those are the things that you typically will think of when you hear somebody discuss of a patent. The next type of patent is a design patent. And a design patent covers what a product looks like. It doesn't cover the utility or the function. That's what a utility patent would be for, but it covers the aesthetic appearance of a product. A third type of patent that is recognized in the United States is a plant patent. And a plant patent they're rather rare, but they generally relate to covering a asexually reproduced new plant that is other than a tuber. If you have any questions on plant patents, you're probably in a very rare minority because we rarely run across them, but we would be glad to help you with any questions you have on plant patents. Copyrights are pretty well known by most people as well. Copyrights, rather than covering a utility or how something works or what something does, a copyright will cover an expression of an idea. It doesn't cover the idea itself, but it covers how it is expressed. So if you have an idea and you write it down in a book, the book itself or the expression of that idea is covered, but the idea that you put in the book is not actually covered. That idea is being given to the public. Other things besides a book that may be copyrighted are public performances, music. Music can be covered both on the lyrics or the underlying musical composition. Audio recordings. This actual presentation would be copyrighted both from the audio that you're hearing as well as the slides that we've presented. Again, just for example, the ideas that we're presenting to you would not be protected, but the way that we're expressing them to you would be. A couple other notable copyrightable subject matter would be paintings, photographs, things like that. The next area of intellectual property that we deal with would be trademarks and trade dress. Trademarks and trade dress are used as a source identifier. They're used so that when a consumer buys something or goes to get a service under a trademarked product, they know that they're getting a specific good from a source. They may not know where the source is or who the source is necessarily, but the trademark represents a specific source. Perfect example, at least in the U.S., is the McDonald's trademark. You may not know who McDonald's is owned by, where they're located, but when you order a Big Mac, you know what a Big Mac should taste like and what it should be, what it should consist of. Again, trademarks are used for source identifiers. The fourth area of intellectual property in the United States is trade secrets. And trade secrets are rather interesting. What they're used for is they're valuable, confidential information. And that can be a product, a process, a formula, design, compilation of information, etc. A good example is if you have a product and you use it to form a piece of metal. The product that you're using to form that metal, if you keep it secret and no one else knows that you're using that to form the metal, could be a trade secret. You may have found some device that's used in a completely irrelevant environment to form this metal. Maybe it's in a hospital or something like that, but it does a really good job. And the value in the fact that you are the one that figured out how to use this product that's normally not related to this industry is the trade secret. And therefore, if you keep that secret, you have value that other people may not know about. A couple comments on intellectual property generally. Intellectual property, it gives you the right to exclude others from exploitation of the asset. It doesn't give you the right to actively exploit that. This is one misconception that a lot of people have. It is an exclusionary right. The point being, if I have, say, a patent on a product, I have the right to exclude others from using that product. I do not have the right to actually use the product myself. And a perfect example is if person A has a pen, person B invents a pen cap, and person C comes up with the idea of actually putting the pen and the pen cap together. Person C has no right to actually make his patented combination of a pen and a pen cap. That's because he's prevented from making the pen by person A, and he's prevented from making the pen cap by person B's patent. Again, he has a patent on the combination of a pen and a pen cap and has no right himself to actually make and sell the patented pen cap combination unless he gets the rights from parties A and B to the pen and pen cap. The other thing is that you could have legal requirements. Various territories may prevent you from making a device for national security, etc. And therefore, even though you have a patent from that government on the product or device, they may say you still legally cannot practice that device. Intellectual property is generally thought to be territorial. That means that United States patents only have effect generally in the United States. So if you have infringing activities occurring in Europe and someone has a United States patent, we cannot typically stop that activity in Europe without a European patent. That can be problematic if your products go throughout a lot of areas in the world, because generally you'll need patents in most of those countries. Where we can help counsel clients as to ways to economically cover territories, whether it be hitting major markets. A lot of times we'll counsel clients to get several patents in Europe, maybe in 2 or 3 principal countries, a patent in the United States, and maybe 1 or 2 patents in Asia, rather than trying to cover all areas but if they can cover the super majority of their market, that may be enough. But again, we'd be glad to help any of your clients determine what would be good territories to try to obtain patent coverage or other intellectual property coverage. It's referred to as an intangible property. That's relatively self-explanatory in that, unlike physical property, you can't hold it, grab it. There's no ground, no product, etc. Intellectual property can overlap. You can get, for example, on one product, you can get a utility patent on how it works, or the way that it works, or what it is. You can get a design patent on the way that it looks. You could get a trademark on the company that makes it, the name or the branding of it. You could also get trade dress on the way that it looks, which is very similar to the design patent. You could get a copyright on any user manuals that may be used for it. You could get a copyright potentially on the way that it looks if it has enough artistic expression included in it. And you could also use it. You could do trade secrets around a product. If your product is if your patent, let's say, is on a product, you could trade secret special ways of using it. You could trade secret various aspects of the product itself. You are required in the U.S., if you have a patent on a product, to disclose the best mode. You have to disclose within a patent how someone can make it or use it without unreasonable experimentation. But there are things that within an individual product you may be able to trade secret if it's not directly related to the actual things that are patented. A couple policies behind intellectual property. These generally relate throughout the world, but in the U.S., one of the policies for intellectual property is to reward the owner for their public disclosure. The primary intellectual property under this category is patents and copyrights. The theory there is that someone who has invested a lot of money in a machine or a process or even in copyrighted material has to have some motivation to give that information to the public rather than to always keep it as a trade secret. And with regard to a patent, the owner of the patent is given a limited monopoly to exploit their discoveries so as to have economic gain, but then to also give that information to the rest of the world so that they can use it and then expand and extend the knowledge and information throughout the world. Similarly, another policy is to protect economic vitality. Trade secrets primarily fall under this area. It's when someone comes up with a concept that may not necessarily be patentable but has economic viability, but once somebody knows that it is how it works or what it is, they could easily reproduce it without much investment. A trade secret allows them, if they keep it secret, to get economic benefit from that concept that they've invested time and money and resources in developing, as long as they do, again, keep it as a trade secret. A third policy for intellectual property is to protect the consumer. Trademarks and trade dress are, as I mentioned, used as a source identifier. And it's the policy behind them is not necessarily to protect the owner of the trademark. It's to protect the consumers and the public as a whole, so that they are not cheated or prevented from buying what they actually think they're getting. When they go again to McDonald's to buy a Big Mac, they know that they're getting a Big Mac rather than a Whopper or any other hamburger. They know exactly what they're going to get. When they buy a BMW or a Mercedes vehicle, they know what vehicle they're getting, and they're not getting something that is a knockoff made of inferior parts from a different company. So those are some of the initial policy considerations relating to intellectual property. I'd now like to transition into discussing patents more specifically. Again, that's more of my specialty. I do practice in all of the areas of intellectual property, but this is the one I find the most interesting. So a patent, what does a patent do for you? Again, it's an exclusionary right, and so what does it allow you to exclude others from doing? In the U.S., a patent allows you to exclude others from making the product in the United States, selling the product in the United States, even making an offer for sale for the product in the United States, preventing others from using the product in the United States, as well as importing the product into the United States. So again, a patent allows you to prevent someone from making, selling, offering for sale, using or importing a product, or using a method or other invention within the United States. Again, the rationale for patents is to promote the disclosure of information. What do you get for disclosing that information? You get a limited monopoly to reward your investment and the time spent developing the concept, the invention or the product, the method, etc. In the United States, and typically this is the same throughout the rest of the world, you get a 20-year patent term. Now that isn't a 20-year term from when the patent is granted. In the U.S., it's 20 years from the initial U.S. filing date. So when I file a patent application in the United States, I will get 20 years from that filing date with some exceptions. First, if I initially file what is called a U.S. provisional application, I will get a 1-year grace period as to when my 20-year clock will begin running. This was introduced to partly marry U.S. patents with patent applications that are coming into the United States from foreign countries, because when a patentee initially files a patent application in a foreign country and then through some international treaties enters the United States with their patent, the period between filing in a foreign country and filing in the United States does not start the 20-year clock running as well. So then third, due to some changes in the law from originally having in the U.S. a 17-year patent term from the date of grant to a 20-year term from the date of filing, the United States has something called patent term adjustment, which is an attempt to guarantee that you should have about a 17-year period of patent term after the date of grant. In the United States, during your term, you have 3 maintenance fees that are due. Generally, they're referred to as 4 years after grant, 8 years after grant, and 12 years after grant. Many other countries throughout the world will have maintenance fees annually. In the U.S., there are no maintenance fees or annuity fees while a patent application is pending. So you can file the patent application, and if it's pending, hopefully it is not, but for 10 years, you'll have no maintenance fees that are due to the government in that time period, where in other countries you could have a maintenance fee every year. So that's one nice thing in the U.S. And again, it's 4, 8, and 12 years after grant. If at any time a client decides that the patent is no longer economically viable, they can forego paying a maintenance fee. However, at that time, the patent will lapse and rights will be lost. All right. There are several requirements for something to be patentable One, it needs to be patentable subject matter. The idea also has to be novel. That means that it needs to be new. Someone could not be novel. Someone could not have done the exact same thing. So, for example, if I claim a chair, my invention's on a chair, and I claim a chair that has a seat, a back, and 4 legs. If no one has ever done a chair with a seat, a back, and 4 legs, my idea is novel. If they've only done 3 legs, my chair is novel. The next level is a little bit harder and makes a little more sense is that it can't be obvious. And this is where my four-legged chair may fall apart, because if someone's done a three-legged chair and a five-legged chair and maybe a six-legged chair, it might be obvious, and I could make arguments why it wouldn't be, but it might be obvious to make a four-legged chair. But again, no one has done an exact four-legged chair, therefore it has novelty, but does not have, may not have met the non-obviousness standard. In Europe, this is often referred to inventive step. And another requirement is that the idea must have utility. Generally, anything will have utility, other than one of the things that can be questioned under utility potentially is a time machine, perpetual motion machines, things like that that are generally regarded as cannot exist. Patentable subject matter. Generally, per the courts in the United States, patentable subject matter relates to any useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. Unfortunately, it's not necessarily as broad as it may seem. You cannot, things that are not patentable subject matter include laws of nature, physical phenomena, and abstract ideas. As many of you may know, in the United States there's been a lot of litigation as to what is or is not patentable subject matter, and a lot of that relates around software as well as business methods. While the government and the law will say that business methods are generally patentable, unfortunately nobody really knows what business methods are patentable. And in general, in the United States, they're moving towards things that relate to processes that are tied to machines or machines themselves or actual products, and moving away from providing protection to business methods. We tend to advise our clients that this is still a very volatile area, to not forego filing patent applications on business methods or software, as there is potential for the area of what is or is not patentable under those types of technology to continue to change. The U.S. recently has transitioned to a first-to-file system as compared to the first-to-invent system. In the past, the U.S. was generally one of the only countries that was a first-to-invent system, meaning that it was not a race to the patent office as to who won if there was a disagreement as to who was the first inventor. Currently, with the first to file, we're much closer to what is being done in Europe. In other countries, it's more of a race to the patent office as to who will win in a dispute. This makes the filing date of a patent application much more important, whether the initial filing date is here or in Europe, and I will discuss the benefits or how we can use filing dates in other countries in the U.S. to help meet the first-to-file requirements. In the past, just to give a little background, under the first-to-invent system, if I came up with an idea and I had it written down and could prove I came up with the idea, and I was working towards reducing it to practice and making sure it was a viable idea, and in the interim while I was doing that, someone else actually filed a patent application on that concept, I could prove or go in and say I was the first inventor and be able to actually get the patent over them, even though I was not the first one to file a patent application. That has generally gone away, except for with some minor exceptions, which will be discussed later under when we discuss prior art. Prior art is what we generally call patent-defeating activities or items or publications, things like that. It's generally something that will prevent you from either getting a patent, or if you've gotten a patent, it is something that potential infringer or competitor will use to invalidate an existing patent. Types of prior art are printed publications, so that can be journal articles, books. Most web pages are now would be considered a printed publication. It can be theses if they're properly categorized and can be searched or found. It could be manuals that accompany products. Another type of prior art is a public use of an invention, so it's not an actual printed publication or something like that, but if you come up with an invention and you use it in the public, that public use and exposing your invention to the public could be considered prior art or a patent-defeating activity. A third area of prior art are sales or offers for sale of an invention. In the U.S., at least in the past, there's been some change under the new laws relating to sales and offers for sale, but even private sales potentially could have stopped patents in the past. So if you have clients that are getting ready to go and meet with potential customers, it is very important that they consider the potential patent-defeating activities of those discussions, and that they should consider how much information they should disclose. Let's see here. The other area of prior art is prior filed patents or published patent applications. They may not have actually been published to become prior art or a patent-defeating activity. In the U.S., there are several exceptions as to when the previously discussed prior art or activities will or will not be patent-defeating. In the U.S., during the transition from the first to invent to the first to file, in the U.S. we always had what was referred to as a one-year grace period from initial disclosure before you had to file, to give inventors some time to try to go out and commercially exploit their invention to see if there's any market before they went to the expense of filing an application. And they've attempted to try to keep that in the current law. So an exception to the prior art mentioned before relating to printed publications, public use, sales, or offers for sale is that in the U.S. you will have a still get a one-year grace period from your own prior art. So if you go out and make a sale or offer it for sale, or you use it publicly, or you write a journal article on your invention, in the U.S., if you put that out in the public, you can still have a 1 year from that period to file your patent application before those activities will prevent you from getting a patent. The problem there is most of your clients are probably in a foreign jurisdiction where a lot of those activities will then make them lose their rights in their own countries. So what I can advise you here is that to the extent that you have a client that comes to you and tells you that they have done one of these prior patent-defeating activities, don't tell them that they're completely lost, but they still might be able to get patent protection in the U.S., but they may not be able to get protection in their own country. So, again, if the couple other minor exceptions is if I was not the one that actually did the prior art or patent-defeating activity, but someone heard of my invention from me and then they went out and publicly disclosed it, those activities would not stop me from getting a patent because they got the idea from me. They weren't really an inventor. They didn't come up with the concept. And so to the extent that someone is putting out my information that they got from me, if I can prove that they got it from me, their activities, if they're within a 1 year period of filing, will not prevent me from getting a patent. Okay. Another exception is disclosures in applications or patents are not prior art if the subject matter is similar to what I've just mentioned, was disclosed or was obtained from me. So if I file a patent application that includes concepts that I later want to file another patent application on, that filing may not be used as a patent-defeating filing because it was my own disclosure. Again, if somebody put my information in their patent application, that information, to the extent that they got it from me, may not be patent-defeating activities, even if it was done before my filing date. Let's see. All right. There are ways to exclude prior art, and one of what you can do is what we call making a priority claim to another application. So if your client files in Europe a patent application today, most countries have become members of some treaties that allow us to delay when you have to enter in other countries. The benefit there is I can file in one country, endure the expense in that country, and then I have a limited grace period as to when I have to enter into other countries, but yet I won't lose the date at which I file, let's say, in Europe. So if I file in Europe today, due to many treaties, I can wait 1 year before I have to file in most of every other country in the world. However, if I file within that 1 year period, I can claim priority back to my original filing date, and it will be as if I filed in the rest of those countries on that original date when it comes to prior art. So if I file in Europe today, tomorrow somebody publishes a writing on my concept. They didn't get it from me, so it would qualify as prior art. But then I wait 1 year to file in the United States. If I claim priority back to the European application, that later filed publication would not be a patent-defeating activity by a third party, and I would be able to use the benefit of my earlier European filing when I'm prosecuting my patent in the United States. Let's see here. There are a couple ways to get an early filing date. One would be, as I said, to file in Europe. There are ways in the United States to try to get an early filing date at a reduced cost. We provide the ability to file what is called a provisional application. A provisional application doesn't have to have all of the formalities of a typical non-provisional application. When you file a provisional application, you will have 1 year to then convert that to a non-provisional. The benefits of a provisional are, again, they don't have to be as formal. You can do simpler drawings. They're much cheaper. One of the downsides that we like to caution people with regard to provisionals is that anything that is not disclosed in a provisional application, you don't get the benefit of. So if there is underlying algorithms that explain how a system works, and those aren't included in the provisional, you won't get the earlier filing date, which can be problematic, as many people think that, oh, I filed a provisional, I'm protected, I can go out and talk about my invention, but then they start to explain things to their customers that they didn't explain to us and that aren't part of the provisional, and those activities then may be patent-defeating activities, particularly in other countries where they do not have the exceptions to prior art or the grace periods, where in the U.S., if I file a provisional, I will have to convert that to a non-provisional within 1 year. So if I talk about my invention in that interim period, I still have my exceptions to the prior art rules that will protect me. However, if I'm relying on that provisional application for priority for a European application, those discussions may be patent-defeating activities when it relates to foreign countries. So we try to really counsel clients when they begin to use provisional applications. In most countries, and in the U.S., you can usually only prosecute one invention at a time, and a lot of times you may have multiple inventions within one application. And so what you are allowed to do is prosecute one application and then file what is called a divisional or a continuation application. When you file that, you will then get the earliest filing date. So if I filed in Europe, then filed 1 year later in the U.S., and then had to file a continuation on another invention, so I'm actually at a third application. That third application can get the priority date all the way back to the European application as it relates to prior art. And in the U.S., you can get priority dates from a design application. It can be difficult, but you are allowed to use a design application as a priority application for a utility application, or vice versa. If you have a utility application, you can use that as a priority date for a design application. I don't have a specific slide on it, but I would like to note that I mentioned earlier that utility patents have a 20-year term. That is for utility patents. Design patents actually have a 14-year term, and those are from the date of grant, and there are no maintenance fees for a design patent. So design patents can have some value as they're, one, much cheaper to get. They have a 14-year term. Once you get it, you don't have to continue to pay maintenance fees. Patent ownership issues. One thing we always like to let people know is that, at least in the U.S., named inventors are presumed to be an owner. So if you have an inventor who should actually have assigned their invention to someone else, with absence an assignment, they are presumed the owner. And you may need to use other agreements to prove up who actually is the owner of the invention. Another issue is joint ownership. Joint ownership is very interesting in that joint owners have the right to utilize, without being at threat of a patent, the patented invention. So if I have a patent and I am a joint owner with party B, and I go out and use the patented invention, party B cannot stop me from using it. Their exclusionary right does not extend to stopping me from using it, nor do I have to ask them if I can use the product or any of the rights that would be prevented from being able to be used by the patent. This can be very problematic when you have joint development. When you have joint development between two companies, such as between a supplier and a distributor, so I manufacture a product for one of my customers, and we developed it together. The question becomes is, if my customer is now named as an inventor or an owner of the patent, I cannot prevent them from then going and getting a second source for the product, because they are an owner of the patent and they have unlimited rights to the patent, and I cannot stop them. They don't have to pay me. There's no accounting unless there is a specific underlying agreement. But in general, joint owners cannot stop other joint owners from practicing the invention that is in a patent. And as you can see, that can be very problematic if you're trying to prevent a customer from second sourcing product if they are named inventors. So you want to be very careful as to how you claim an invention, so that you only claim the concepts that your client came up with, and to avoid including other companies' inventors on a patent to prevent them from having rights. Would like to note within that, if an owner only has to have rights or concepts within one part of a patent. So if I have a patent that covers a car, and for instance it covers one part of the patent covers the engine and another part of the patent covers the transmission, if one of the inventors only worked on the transmission and did not work on the engine, they will have unlimited rights to the entire patent, both to the engine and to the transmission. So you want to be very careful to make sure that you focus your patents on what your client covered, unless there's an underlying agreement in place. Much like the rest of the world, in the U.S. we can now name jurisdiction entities, so you can have a company be the patent applicant. Recent statistics have shown that approximately 58% of all newly filed patent applications are filed in the name of a company and rather than in the name of an inventor. All right, I'm going to move on to infringement questions or issues relating to patents. There are generally thought to be two different types of infringement in the U.S. There's direct infringement and indirect infringement. To have direct infringement, a party must practice all the elements of a patent. So if the patent is on my chair example from before, where there are 4 legs, a seat, and a back, a party must practice all 4 elements. They must provide 4 legs, a seat, and a back. If they're missing the legs and they only provide the back and the seat, they're not a direct infringer because they're missing the legs or any of the other components. Again, they must practice all the elements. Within direct infringement, you can literally infringe a patented product, or you can infringe under the doctrine of equivalence. Literal infringement is where you would have exactly what is recited, such as the 4 legs, a seat, and a back. Under the doctrine of equivalence, they allow you to go after things that may be equivalent to what's already claimed, but slightly different. For example, if you can make it, if the 3-legged chair, somebody is selling a 3-legged chair, if you could argue or prove that 3 legs are equivalent to 4 legs, you potentially could be held to be an infringer. I do note that the doctrine of equivalence is rather narrow. The courts in the United States do not like it because it provides uncertainty. You want people to know whether or not they can practice an invention or produce a product free of patent protection from the claim language. So the courts do not like the doctrine of equivalence. It is significantly limited if there are during prosecution of a patent. And so we'd be glad to discuss that in more detail if anyone has any questions on that. Patents are a strict liability. There's no need for knowledge of a patent when it relates to direct infringement. So whether or not your client knows of a patent, if they are doing an activity in the U.S. that would infringe the patent, they may be liable and may have to stop their infringing activities, again, whether or not they knew of the patent. However, if they didn't know of the patent, the remedies to the patent holder may be limited, but the patent holder may be able to make them stop or move forward with potentially a license or some other arrangement if they want to continue. Indirect infringement. Indirect infringement, there's 2 different types of indirect infringement. There's contributory infringement, and then there's inducement of infringement. Both of those are where generally the person that's being charged with infringement has not performed or made or used all of the elements within the claim of a patent. However, it usually means that someone else has. So what happens is if I make a user manual, I know of a patented product, and I make a user manual that teaches someone how to make that patented product, and I know of the patent, I may be liable for indirect infringement because I am helping and telling someone else to actually commit patent infringement. Both areas of indirect infringement generally require an underlying direct infringement, as I mentioned, but they also generally require knowledge of the patent for you to be held to be an indirect infringer. That can be proved by circumstantial evidence, generally. The big question becomes, and is currently being litigated, and there was a recent Supreme Court decision on it, but that relates to joint infringers. So if, let's say there's a patented method of making the chair, of attaching the back to the seat and attaching the 4 legs to the seat, the question becomes is if I attach the seat to the back to the seat and someone else attaches the legs to the seat, have we now been joint infringers by performing the actual method? Again, the invention is the method of making the chair, not the chair itself, but are we joint infringers of the method? And that is being decided as to how far that goes. If myself and the other party are part of the same company, or where I am one company and they're my sister company owned by another parent company, that would most likely be found to be an infringement. because is likely agency theories there. However, the question becomes, if we're completely unrelated companies or parties, can that be considered a joint infringement of the method? And that's been undecided and is potentially going to be decided by the Federal Circuit on the case that was just decided by the Supreme Court. But again, that is a question that we have been watching and will be watching in the future. Let's see. Defenses for infringement. One of the defenses for whether or not a party infringes is non-infringement. That means they fail to meet all of the elements. Back to my chair, if they don't include the legs, all I have is a back and the seat, I don't infringe. I don't have the third element of the legs. There are questions. A lot of people will say that that technically is not a defense to infringement, because you can only have a defense to infringement if you in fact infringe. So I will include it as a defense. However, some people will be overly technical and say that you can only get to a defense after there has been a determination or an agreement that there is infringement. One of the principal defense to infringement is that a patent is invalid. The patent can be invalid for several reasons. Number one, there can be prior art. As we discussed before, the patent claims could be anticipated. Someone could find in the prior art a printed publication of a chair that has 4 legs, a seat, and a back. That would invalidate my patent. Alternatively, somebody could find try to invalidate my patent on obviousness grounds. They could find in the prior art the chairs with 3 legs, the chairs with 4 legs, and then maybe combine that with another piece of prior art, such as a table that has 4 legs, and make arguments as to why it would be obvious to use the 4 legs from the table and combine that with the 3- or 5-legged chair to render my 4-legged chair invalid over obviousness grounds. There are non-prior art issues for validity. Your claims have to be definite. If they're indefinite so that someone cannot understand what you're claiming, your patented claims may be invalid. You may not have enabled one of ordinary skill in the art to actually practice the invention. So if you come up with the time machine and you didn't teach someone how to make or use the time machine, your claims would not be enabled. Another version, another non-prior art way to attack patents is for written description if you haven't adequately described your invention. Another area for invalidating a patent is inequitable conduct. Inequitable conduct is typically when someone is a bad actor in the acquisition of the patent. They failed to submit prior art that they knew of. In the U.S., we have an obligation to submit any prior art that may be relevant to patentability of a product or a method. And if we know of prior designs, or if we know of sales or things like that that could kill our patent and we don't disclose those to the patent office, we could be held our patent could be held invalid under inequitable conduct reasons. Another defense to infringement is that I have a license. One of the licenses in a simple idea is if I buy the product from the patentee and he sells it to me, I have a license to use it. I may not have a written license, but it's implied that I have a license to use it. Another thing is if there are multiple patents around one area of technology, so there's a patent on the actual product and a patented method of using the product, if that product has no non-infringing uses other than the patented method, there may be an implied license to use the patented method when I buy the product. Again, the patentee has gotten paid from me to buy the product. Well, then they can't come back at a later date and say, oh, by the way, I have a patent on the method. Now you have to pay me again to use what you've already bought. So there's the defense of a license. Other areas under a license, in the United States, we have a very broad repair doctrine. If I have a patent that only covers a combination, such as, let's use a repair part for a vehicle, I have the patent is on the overall vehicle, such as, it has an engine and an oil filter. And I sell my patented car, and it has the engine and the oil filter. Under U.S. law, the owner of that product would have the license to repair the repair part of the replaceable oil filter. So therefore, if they were to if they were to buy a replacement filter and put it on their car, there would be no new infringement. This is much different than in a lot of other countries. A lot of other countries would consider that to be a reconstruction of the patented article and would prevent that activity. In the U.S., that repair part can be stopped if there is a specific patent on the actual repair part. So if I have an invention that covers the car, the engine, and the filter element as a whole, but then I also get a specific patent on the individual components, they would not have the right to reproduce that patented filter element under the repair doctrine to repair their car. Exhaustion is kind of like is another defense, but it falls under the license area. If I've already exhausted my patent rights and have been paid for my patented invention, I can't then come and sue again. Laches and estoppel, those are the general laches and estoppel issues. Laches and estoppel relate to if I give someone the belief, if I tell them that I'm not going to sue them on a product and they go out and produce it, then I cannot go back and then later sue them. I can't base them into making a product so that I can later sue them. There can be time restraints. Generally, it's believed that a 6-year time restraint, so if you know of infringement and you wait more than 6 years to enforce, you may be prevented from enforcing your patent rights. And a new defense to patent infringement is a secret prior use defense. That is, if you have been using a patented method or product in your own factory for more than 1 year prior to the filing date of the patent, you can say that I've been using it in secret, and you cannot sue me for the use thereof. Now, that is a personal right. It's my understanding that that cannot be extended. So if I've been using a product for more than 1 year prior to the patentee's filing date, I cannot then sell that product to someone else. They will not get the benefit of my 1 year. They don't get to use that or toll or tack onto my secret prior use in general. There's probably some exceptions to that, such as if a company is sold, if all of the assets are sold, a complete stock transfer, etc. The secret prior use may still be in play, but that has not generally been litigated, so there's always the option or possibility that that could change. Remedies. A patentee has several principal remedies for infringement, monetary remedies, as well as injunctive relief. Primarily, monetary relief is what is available. You may get some immediate injunctive relief, but generally it's hard to get permanent injunctive relief, as patents are generally used to generate economic value. It is very hard in most circumstances to prove a non-economic reason why an injunction would be permissible. You should always most likely be able to prove some sort of an economic resolution. One example where it may not be the case is if a potential infringer is going to go out of business, or they're in bankruptcy, or something along those lines. You may be able to get a better injunctive relief. But if they're relatively financially stable, it can be difficult to get injunctive relief. Under monetary damages or remedies, there's compensatory damages, which are to pay back the patentee for any potential lost profits. Compensatory damages can be actual lost profits. If you can prove that you would have made the sales absent the infringement, you may be able to get your actual lost profits. However, it is more typical that you will end up with a reasonable royalty. A reasonable royalty is usually determined as two hypothetical arm's length negotiations between two companies as to what license agreement or license licensed royalty would be determined between those companies. Generally, it is usually not as good as lost profits and much lower than the patentee would like. However, that's usually what ends up being awarded is a reasonable royalty. In the U.S., the courts can provide enhanced damages, and those are for extraordinary cases. That's typically where there's willful infringement of a patent, where somebody knows there's a patent and they go out and practice the invention anyways. Ways to prevent practicing an invention without being willful is potentially if you have a very good invalidity position, if a competitor believes that the patent is invalid over prior art, or they know of that they don't think they infringe, and they have a reasonable position as to why their product doesn't infringe, they can potentially avoid enhanced damages. Enhanced damages can be a trebling of any monetary damages, which can be a pretty big stick if you can get it to wield in a litigation. Another monetary damages is attorney fees. Attorney's fees are, again, in exceptional cases, but that can usually be applied against a patent holder if there's inequitable conduct. So if the patent holder committed inequitable conduct during the prosecution of the patent, they may be liable for the potential infringer's attorney's fees. In the opposite direction, if a competitor is held to be a willful infringer of a patent, they may be liable for attorney's fees. And another way is if there's bad faith litigation tactics, which relates to the attorneys or the strategies that are being presented by either the patent holder or the potential infringer. So there are numerous ways to get monetary damages. Finally, for compensatory damages, back to lost profits and reasonable royalties, generally to get monetary damages in that area, you have to have given the infringer, or the infringer has to have had notice of the patent. And there's two ways to get notice to a competitor. One, actual notice. You see their product, you send them a copy of the patent, you tell them you think it infringes, and now they're on actual notice. From that time forward, any of their activities may be subject to economic or monetary remedies for the patent holder. Another way is with constructive notice. Constructive notice would be by using patent marking. For patent marking, again, it's used to recover economic remedies, and there's ways to do patent marking. You can actually mark a product or packaging with a patent number. In the U.S., you would put patent and then list the patent number, or patent period with the patent number. However, the U.S. has also moved towards a very beneficial use of virtual marking. In the U.S., you can list patent and then list a website afterwards, whereas you can list the patents that you think cover a product or a method, and then list the product or the method, and then list the patents underneath it, and that would be considered constructive notice. The benefit of virtual marking is that in the U.S., if you falsely mark a product, you could be liable for damages. And using the virtual marking, it allows you to change your marking of a product without having to change the product itself. In the old days, when lots of things were molded, such as engine blocks, things like that, the only way to mark the product was to build into the mold the patent numbers. However, with this, rather than having to spend thousands of dollars to change your mold, you just go to your website, you hit delete, you remove the patent number, and you're no longer in violation of the marking statute, even though it says patent in a website. But because when somebody goes to the website, it will not have any patents listed for that product, therefore you're no longer marking. Couple requirements for virtual marking. The website has to be freely accessible to the public. You can't require a password. That kind of goes without saying, but the point there is they have to be able to tell what is or is not covered on the product. Let's see here. Again, the pros of that, it's very easy to update it to the extent that your patent lapsed or you don't want to pay the maintenance fees anymore, you can, once the patent lapses, you can immediately update your website and you're fully in compliance with the marking statutes. One of the problems with patent marking on a website is that your competitors do not have to get your product to know what patents they think are covering it. And two, they can also look at your list of patents and see what product areas you may be selling products in. And for large companies that sell consumer goods, that's not as big of an issue because it's a lot of times can be very easy to get the actual product. However, for companies that sell one-off or two-off machines or maybe 5 machines that are very expensive, they may not want to use the virtual marking because that may identify to their competitors what machines they're actually selling. And if they're several $1 million, most likely their competitors are not going to want to go and buy that machine just to see whether or not it's marked, etc. But there can be some cons for companies that don't have high volume products. Again, it can be on the product itself or on the packaging if it's not possible to put it on the product. One of the things that is very popular now is challenging patents. Patent litigation in the United States, as you may know, is extremely expensive, specifically if you go all the way through trial. It's very protracted. It takes an extremely long time. And for clients from other jurisdictions and outside the United States, this can be very difficult to comprehend, as many other countries have rather quick patent courts. In the U.S., there are numerous ways to challenge a patent outside of the courts. You can file an ex parte re-exam at the United States Patent and Trademark Office. And our ex parte re-exam is something where a potential infringer or a competitor will present a written, effectively a brief explaining why the patent's invalid. They will submit that to the Patent Office. The Patent Office will decide whether or not they generally agree, and then they will do a re-examination of the patent. In an ex parte re-examination, after the submitting of the initial re-examination request by the requestee, they have no more participation in the proceedings. This can be a drawback if the patentee then overcomes the initial documents that are presented, or if they are allowed to persuade the examiner as to the teachings of the prior art that's submitted. However, it's much cheaper. You shoot your shot across the bow and you're done. You don't have to continue to fight. Another level of way to challenge patents is inter partes review. Similar to the old inter partes re-examination, in this situation you're allowed, this is a more adversarial proceeding where the person who submits the request for the inter partes review, which is typically a competitor or potential infringer, they are allowed to fully participate in the whole proceeding. This is much more beneficial where you present a brief and then the patentee comes back and they are allowed to potentially persuade the patent office as to why the original briefs are wrong. You are then allowed to combat what the patentee submits. So inter partes review are much better from that standpoint. However, they are significantly more expensive. So that is one of the things that would be considered. The U.S. has recently instituted post-grant reviews. Post-grant reviews apply within the first 9 months after a patent is granted, and they allow for various different things to be presented. They're more streamlined. They're supposed to be done rather quickly. Another way to attack patents is there's a covered business patent review. Beyond the kind of the scope of this presentation, beyond that, before a patent grant, people are allowed to submit prior art to the patent office. We generally advise against that unless the client is an extremely low budget client and wants to try to prevent the patent from issuing. However, much like ex parte re-examination, the patentee has the right to overcome what you've submitted. You're not allowed to generally to put many arguments with those submissions. So you're giving the patentee an opportunity to overcome your prior art without you being able to object to or counter any of their comments relating to the prior art. One of the other problems is that prior art, the patent is now presumed to be valid over that prior art, as it is presumed to have been considered by the patent examiner. Now that the patent, the United States has transitioned from the first to invent to the first to file, we have moved away from interferences, which interference was when someone had invented first, but somebody else filed before them. They were allowed to initiate an interference proceeding to say that they were the first inventor. Those are going away due to the first to invent. However, they are being replaced with the derivation proceedings. This is the proceeding that would go on when Party A discloses to Party B, and Party B potentially files before Party A, but the only way Party B came up with the invention was that they got it from Party A. So there would be a derivation proceeding to determine as to where Party B got the invention. Not many of those have been filed. I don't believe any of those have actually been filed at this point. However, we see those as probably being very limited, as interferences themselves were extremely limited as well. And I believe that is the end of my presentation. I'd be glad to take any questions that you may have. Please contact me either by phone or by email, or anyone else at our firm. It's been my pleasure to present U.S. intellectual property issues to you this morning.
Thank you for attending the 5th and final session in our 5-session series. We will probably pick up the program again next season. We have not yet determined the schedule, but we will announce it soon. Thank you.